They can hear? Okay, great, wonderful. Yeah, all good. Okay, thank you everybody for joining us for this session. I'm Arietta, and this is the wonderful Annie. We are from Ofcom. I'm responsible for the age assurance policy for Part 3 services, and Annie is responsible for Part 5 services in policy development. So we're going to accomplish a couple of things here, hopefully, and discuss a bit about what Ofcom does specifically related to the Online Safety Act. But before then, just a bit of a slight overview in terms of what the OSA is. And if we could pop to the next slide, thanks. So the Online Safety Act represents a significant opportunity for us to create a safer online environment for all UK users. And Ofcom is very committed to transparency and effectively implementing this new framework to achieve the goal. And we've already started doing this with our legal harms consultation, which is a very first important step in this wider journey. So what we'll cover in this presentation are a couple of things. Firstly, our role and our purpose. The second will be our sort of approach, our priorities and implementation plan. Thirdly, our expectations for this new framework. And fourthly, how all of this kind of relates and interlines with age assurance. Great. Right. So what is the purpose of the Online Safety Act? So firstly, our role is not to instruct firms to remove individual or particular pieces of content or to take down specific accounts, nor is it to investigate individual complaints. Rather, our role as the regulator is to tackle the root causes of harm online in a proactive and upstream manner. And what that looks like is focusing on improving services, systems, and processes in order to address and tackle that harm. So this is, as I've said, a proactive approach, which we think will create more systemic improvements and will reduce harm at scale. So who are we talking about when we refer to regulated services? So this will essentially include user-to-user services, search services, and pornography services. These are the kinds of services that are going to need to comply with the duties under the OSA. And there are a variety of duties. They're all very specific to the type of service, but it's in essence, the kind of first thing that services will have to do is carry out risk assessments to assess the risk of harm to all users from illegal content. And on a secondary level, if they're likely to be accessed by children, they will have to risk assess for content that's harmful to those children. On a third level, they will then have to take effective steps to mitigate and manage the risks that they identify in those risk assessments. And they'll have to have additional duties, such as having clear terms of service about how their users will be protected from encountering those types of harmful content. They will also have to give users the ability to report illegal content and content harmful to children, and will have to enable users to be able to easily complain when they feel their posts or potentially accounts have been wrongly blocked or removed. And finally, services will also have to consider the importance of rights such as free expression, privacy, when meeting their new duties. We have three kind of core stages to our implementation of the regime. The first is tackling illegal content, which we've already started our consultation work on. The second phase is regarding content that's harmful to children. And the third phase is implementing the categorization of duties of services. So as part of this wider approach, we have a series of consultations, which include the codes of practice and guidance, which we as Ofcom are mandated to produce under the Act to help services comply with their new statutory duties. So there's no actual obligation for services to apply these codes of practice measures. They in effect act as a safe harbor for compliance, and regulated services could potentially take alternative steps rather than taking the measures that we will be outlining in the codes. Great. So what is our approach? Oh no, yeah, the next one, I think. Okay, fab. So our key objective is, as I've stated, to make the digital world safer for people in the UK with additional protections for children. And the key thing here is we want to accomplish this goal without compromising adults or children's rights, such as their rights to information, expression, participation, so on and so forth. The Act is a fairly complex piece of legislation. It's very novel. It covers a wide range of harms, and it's estimated that about 100,000 services are going to be in scope of this regulation, many of which are not headquartered in the UK. So that's why our objective here is really important, and it really informs all of the kind of work that we're currently doing. Now, to answer the question of like how we will drive change, so we will focus again on systems and processes that services have in place to assess risk and then minimize the harms. And there's a couple of key ways that we hope to accomplish this. The first of which is establishing baseline standards. And this is going to be something that we essentially accomplish through our codes and the guidance that we're producing, which we hope will set very clear minimum standards, but also will provide some needed clarity and guidance to regulated services in terms of the measures they can take to comply with their new duties. The second layer here is driving industry improvements. So this is done through a variety of different ways, but one of the core ways we accomplish this is through our one-on-one supervision with those regulated services. Typically, this is kind of focused on the highest reach, largest services, although we also do some proactive engagement with smaller services who are regulated under this regime. The third level there is assuring compliance. So again, this is in large part working with services to kind of drive improvements systemically within their services, but also, of course, where enforcement action is necessary, we do and will be taking it. And then the fourth level is holding services to account, so promoting good practice and holding services to account where they've been maybe a little bit naughty and are not complying in the way that we would like them to. So we have four specific outcomes that we want to accomplish for the first 3 years of the regime, the first of which is governance. So governance is a key kind of element to promoting the culture of safety-centric, safety by design approaches that we'd like to see services take up. So this is essentially in line with risk assessment. So risk assessments are a key component of the Online Safety Act, but governance is really necessary to establish the internal work culture and rules and processes so that services are able to effectively manage and mitigate the risks that come out of those risk assessments. The second level here is through design and operations. So we want safety by design to be embedded in the heart of these services. And there's a variety of different measures that services will have to take in order to do this. So for instance, I mentioned clear and accessible terms of service, easy reporting systems for users. All of these things will be covered in our first codes. But we also want services to take very specific steps to address particular harms, specifically with relation to children, who are obviously our first and top priority. We'll also want services to address online child sexual abuse, including making it harder for groomers to identify and contact children, and using hashing and other technical measures as well to reduce the spread of CSAM online. The third level here is choice. So to be very clear, users are not responsible for their own safety. That responsibility lies firmly with the services who design those products. But adults should also be given the tools under the Act to be able to make their own choices about their online experience and about potential additional layers of protection that they would like. So choice here for users to feel empowered about their online experiences is very important to Ofcom and to our strategic priorities for those first 3 years. And the fourth kind of goal is transparency to drive trust. And there's this threefold. So firstly, it's transparency between services, trust and safety measures. Secondly, it's about Ofcom's own transparency as a regulator. And then thirdly, it's the transparency in how we engage with stakeholders, civil society, international policymakers, academics, to ensure that our policy is informed by expertise and evidence at all times. Great. So some of the changes that we're expecting to see as a result of the Act are firstly, that services are more consistently and transparently prioritizing their user safety. Secondly, that it will be harder for there to be a dissemination of terrorist content online and the threatening of violence. Thirdly, that it will be harder for fraudsters to scam vulnerable users. For that, child abusers will be less able to find and disseminate CSAM material, as I mentioned previously. Fifthly, that it will be harder for children to encounter porn online. And finally, that services take steps to prevent children from being recommended PPC, which is primary priority content. So that's things like suicide or self-harm content. There's a lot of other goals that will come out of the Act, but those are the first couple of things that we hope to see in terms of the changes that services make. Now, I'll quickly pass to Annie to walk us through some implementation bits before I dive into more age assurance specific topics.
Thanks very much, Arietta. I'll just do this one down here. So what's our plan for implementation? Now, I'm about to show quite a complicated slide. Anyone that's worked around the Online Safety Act will know that it's complicated. There's lots of elements and there's lots for Ofcom to do. So that's kind of my complication warning. Let me stand up so you can see me over there. This is our implementation plan. So as Arietta said, it's split into 3 phases. Phase 1 is about illegal harms, and so we published a consultation in November of last year. The consultation is now closed, and the team are very, very busy reading all those responses, analysing them, analysing new evidence that has been presented, and starting to work towards drafting those final codes and guidance for illegal harms. This second section, really important for us because it's all about age assurance. It's child safety duties and pornography. So we've published 1 consultation already on this. Again, it was the end of last year and the consultation has now closed, and that was on our guidance for providers of pornography. And that's all about age assurance, and I'll kind of go into a bit more depth about that later. And we're going to be looking to publish our final version of that at the start of next year. And then in May of this year, we will be publishing our codes and guidance for the protection of children. Arietta is working very, very hard on getting that done at the moment. And that will include age assurance. We have to recommend highly effective age assurance as part of that consultation, but loads of other measures to make children's experiences online much, much safer. And then finally, phase 3 is the duties for categorized services. So as part of that process, we have given advice to the Secretary of State on how services should be categorized and the thresholds that should be set. And then we'll be consulting on guidance for transparency as part of those duties on categorized services. And later in the process, in 2025, we will be consulting on the rest of those duties on categorized services. And I think relevant for this week, part of that is a user identity verification duty. So that kind of different to age assurance, but has a real tie-in. So that'll be coming in 2025.
Yeah, so we're very busy in summary, and we're very tired, but we're doing our best. Right, so how does all of this relate to age assurance? So there's 2 specific types of services in the Act that will need to be using age assurance. So firstly, we have Part 3 services. So Part 3 services are essentially user-to-user services and search services. And these are services who are likely to be accessed by children and therefore have child safety duties. They have 2 kind of core duties. They have to prevent children from encountering PPC, which is primary priority content. And that's content that includes pornographic content. It includes content which encourages, promotes, or provides instruction for suicide. It includes self-harm and eating disorder content. And as per the Act, services who do not prohibit, i.e. they allow, 1 or more forms of this kind of PPC, they will have to use highly effective age assurance within the protection of children codes that they'll need to use in order to be compliant with those child safety duties. The second kind of group of services are the Part 5 services. So those are the services that Annie's doing the sort of policy development for. And they host pornographic content that they themselves publish or display by the provider. Rather than it being uploaded by users, for instance, in a user-to-user service. And these services also must use highly effective age assurance to ensure that children are not normally able to access pornographic content. Right, so a couple of more specifics on Part 3 services in particular. So they have 2 kind of core duties. The first is preventing children from encountering PPC, which I just talked about, and the second is protecting children from this other type of content that the bill lists, which is priority content and then non-designated content. And yeah, okay, great. So the Online Safety Act essentially requires Ofcom to produce codes of practice to support services to comply with their duties, including the duty to prevent and then protect children from PPC or PC and NDC content. The codes will recommend some targeted measures about these harms, and they will of course be detailed, proportionate, and technically feasible. Those are all very important components in the policy development process at Ofcom. Next slide. So we are currently now in phase 2. which focuses on our child safety duties and pornography. As Annie stated, we've already published and consulted on our draft Part 5 guidance for providers of pornographic content, and that consultation closed in March of this year, yes. And we are currently analyzing the responses and feedback that we had as a result of that consultation, and we will now be publishing the consultation on the children's safety duties and codes of practice this May. This is why we look really tired, because it's coming out very soon. We welcome all of your feedback to that consultation when it comes out, and we'll be able to speak to some of the more specific measures when it is public. And I'll pass to Annie now to give you a bit of a deep dive in terms of Part 5 specifically.
So I can go into a bit more detail because this is something we've already published, and that is the Part 5 guidance for providers of pornographic content. So I'll just sort of run through what this guidance covered and how we're planning to kind of enforce and our enforcement guidance around that. Could you do the next slide for me, please? So Ofcom is required to, under the Online Safety Act, is required to publish guidance to assist service providers who publish pornographic content on their online service to comply with Part 5 of the Act. The Act requires providers to use age verification and or age estimation to ensure that children are not normally able to encounter pornographic content on the service. So that's a real mouthful. But that's the sort of the Act parameters that we're working within, so that children are not normally able to encounter content that is regulated provider pornographic content, and I'll break down through the presentation what that kind of means. And so, just as a note, we refer to age verification and age estimation collectively as age assurance, and that's defined under the Act as well, that those two things kind of constitute age assurance. And the Act requires that age assurance is of a kind and used in such a way that is highly effective at correctly determining whether a particular user is a child. Again, that's a very kind of wordy bit from the Act, and that's what has guided us to our recommendations, that sort of wording of highly effective at correctly determining whether or not a particular user is a child. So service providers must comply with those duties around implementing age assurance, and also those other duties on the other side to keep a written record of the kinds of age assurance that they use to comply with this duty. So this is how our consultation was broken down. So first of all, we provide guidance on the scope, who's in scope, and how you determine that. And then we provide guidance on the age assurance duties themselves, and then on the approach to record keeping duties, and finally on how we are assessing compliance with those Part 5 duties. And I'll talk you through each of those elements now. So firstly is scope. So the Online Safety Act is a bit funny in that it kind of divides pornographic content up between this Part 5 and Part 3. And we've dealt with Part 5 first, and this is sort of how you make a decision about whether content or parts of a service are in scope of Part 5. So we set out 3 steps for doing that determination. The first step is about types of content. So a service is in scope if regulated provider pornographic content is published or displayed on the service. So that kind of form of word, regulated provider pornographic content, that basically means that the content itself, the pornographic content, is uploaded by the owner of the service, rather than, for example, by users of the service. And the next condition is that the service is not out of scope of Part 5 or exempt. So exempt might be that it's user-generated content or content that appears in search results, or it might be that it's pornography that is already regulated by Ofcom's on-demand program services regulation, which is sort of in the kind of broadcasting media side of Ofcom's work. And then the next condition is that the service has links to the UK, and the way that that has been defined is that they must have a significant number of UK users, or have the UK as a target market. So I think the key point here again is that it's this kind of regulated provider pornographic content. So the content is published and displayed by the owner of the service or someone acting on behalf of the service. So, and that includes kind of all forms of content. So it's moving images, audio and audiovisual content. It does not include written content. That's kind of one of the key exemptions. And like I said, this does not include pornographic content generated by users or which appears as a result of search services. And this will be dealt with under Part 3 of the Act and in the consultation that we will be publishing in May. So it's important to note that content uploaded by users is going to be dealt with, age assurance will be required, and we hope that once all these duties come into force, wherever pornography is found on the internet, children should be protected from it. And then also to note that sort of tube services that tend to mostly be user-generated content, but have some have some content uploaded by the provider. Although the different types of content are dealt with differently, the duties are ultimately going to end up being the same. If there is pornography, there should be age assurance, and children should not be able to encounter it. Okay, so the age assurance duties. So, as mentioned, service providers must implement age assurance in such a way that is highly effective at correctly determining whether or not a particular user is a child. So to ensure that a chosen method or methods of age assurance are implemented in a way that is highly effective, we've proposed that service providers should ensure that the overall age assurance process fulfills these 4 key criteria. So the first is technical accuracy, which is how an age assurance method can correctly determine the age of a user under test lab conditions. The second is robustness, which is the degree to which an age assurance method can correctly determine the age of a user in unexpected or real-world conditions. Next is reliability, so the degree to which the age output from an age assurance method is reproducible and derived from trustworthy evidence. And finally, fairness, the extent to which an age assurance method avoids or minimizes bias and discriminatory outcomes. So in the guidance, we set out practical steps for achieving each of these criteria. And once the provider has chosen a highly effective age assurance process by considering each of these criteria, it should then ensure that the process doesn't exclude adult users from accessing legal content that they have a right to access. So we provide additional steps for how a provider can consider accessibility and interoperability as part of that process. And we provide kind of illustrative case studies to show how the criteria principles might fit together. So if you look at the guidance, it should all come together a bit more around those case studies, and you can see kind of how these criteria might be applied. And then on to the next slide, please. We also provide some examples of age assurance that could be highly effective, and that wording of could be highly effective is quite important to us. We don't think that any age assurance method on its own is inherently highly effective. It's all about how it is implemented and that is implemented with those 4 criteria in mind. So this list on the right are those methods that we think have the potential, based on the evidence that we have seen, to be highly effective if implemented properly. And then on the left are those that we do not consider capable of being highly effective, no matter how they are implemented. So that's self-declaration, or the use of debit cards, where the user doesn't have to be 18 to have access to one. So we haven't included age assurance whereby a parent vouchers for the age or age status of a user as something that could be highly effective, because we haven't seen evidence to support that this could be applied highly effectively, but we also don't know if it's that relevant for pornography and that 18 barrier. We don't know if people are going to be getting parental consent to be accessing that kind of content. So on to the next slide, and that's the record keeping duties. So the record keeping duties are about keeping a record of how you apply the age assurance, and that's how you apply it to be highly effective, but also how you apply it in a way that is privacy preserving and with regard to the ICO's work and data protection. Glad to see the ICO are here. And we work very, very closely with the ICO. We'll be presenting joint sessions with them this week. And we kind of meet with stakeholders together. And if we are reviewing a service's written record and we think there are data protection concerns in that record, we will refer that to the ICO where we have concerns. So we want services to really understand that we work side by side, and they should be complying with their online safety duties, but also with their duties related to data protection. And so our guidance on this sets out how a written record should be kept, that it should be easy to understand, durable, easy to locate, and up to date. Yeah, we'll review those written records to ensure that compliance is taking place in the way that it should. Next slide, please. So finally, our approach to assessing compliance with the Part 5 duties. So our general approach to enforcement under online safety is set out in our draft online safety enforcement guidance. So that was published in that first consultation, in that phase 1 you saw at the top of that slide. That sets out in general the principles under which we will enforce. And so those principles are transparency, accountability, proportionality, and ensuring that regulatory action is targeted only at cases which require it. Sorry, what a terrible cough. It also outlines the different enforcement tools that we might use and explains how we prioritize cases that come to our attention. So it really sets out kind of how Ofcom does enforcement across the Online Safety Act. For Part 5 specifically, we acknowledge that there are complications, especially for those services that might fall within both Part 3 and Part 5. But as we progress to publishing our consultation on Part 3, I think it's going to become clearer and clearer for those services, like I said, that if they have pornography, they should have highly effective age assurance, and it will get simpler and simpler, but we will work with those services to help them to understand those duties so that we can see swift compliance with the duties that they are subject to. And finally, this is kind of how Ofcom is set up to support and encourage compliance. We've grown a lot in the last couple of years and had to build a kind of new structure to ensure that we can develop these codes and guidance, and then we can communicate them properly to services, and then we can ensure that they are complying. So as you can look in the middle, the orange square, that's the policy development team where Arietta and I sit. So we write the consultations and consider the evidence and kind of put together the policy that we've talked about in this consultation, in this presentation. And then for the technical elements of those consultations, we have 2 technology teams, so a technology policy team and a trust and safety tech team. You hopefully will see some of the trust and safety tech team here this week. Within that team, there is a digital identity and age assurance technology team. So we've got some real dedicated resource of some quite clever people who really understand the technology and kind of keeping up to date with all the developments in the age assurance and digital identity world. We also have a supervision team, so this is new to Ofcom, the purple block, and so they own the relationships with regulated services, and they're already building some really, really productive relationships. They've been meeting with pornography services over the last few months, getting to understand what they're already doing, what are the barriers they see to complying with the regime, and explaining the duties. I've been going along to the meetings to talk about the Part 5 guidance and answer any of their questions, to encourage them to engage with our consultations. And that's going to be a really, really productive relationship as they as we move to the date in which they have to comply. Thank you, my glamorous assistant. And so the plan and our hope is that where there are issues with compliance or where our expectations aren't quite being met by services, is that supervision relationship will be strong enough to challenge services and bring them into compliance, explain where they might be falling short, and collaboratively get them to a place where we're happy with how they are complying. But that might not always be possible. And for that reason, we have the supervision team have a very, very strong relationship with that legal and enforcement team, so that where we are not happy, that our expectations are being met, we can move to enforcement and kind of bring service into compliance, make sure they're meeting their duties, and I think relevant for my work, make sure they're protecting children from accessing pornography, which is very, very important and long overdue, I think a lot of us think. Okay, thank you very much for listening so patiently to all of that. That was quite a bumper presentation from us. Hopefully we've left plenty of time now to answer any of your questions, comments, thoughts. Yeah, I can already see some hands, so I'll throw it over them. Mm-hmm. Yeah, so what we've said in our guidance is that it must be at the gate. It should be at the gate of the service before any pornographic content is accessible. We've not been super prescriptive about the user journey because we want this to be as neutral as possible, and we want services to be able to apply it to their specific user journey in the safest possible way. But we will be we'll be assessing the decisions they make and recording their record keeping, and we'll be asking them questions about how does that fit with each of our criteria, how is that robust, how is that highly effective age assurance if we are not happy that the place that it has been put is going to be protecting children. Do you think that holds true for the Part 3 guidance as well?
So on part 3, I can't tell you exactly what we're going to be proposing or not proposing because that's going to be coming out in May. But I think as a general principle of policy development when it comes to these thorny issues, we know that a lot of services know their service best, obviously, and they know where that harmful content lies. So I think the general principle is that a lot of the times the burden of proof is on services to show us that their measures that they'll be taking will be effective, and then we'll do the compliance assessment as follows. But the specifics on AA, the timing, the types, all of that will be covered in our measures. So I won't go into too much of that right now for part 3. But for part 5, Annie's very clear on all that.
There's a question over there, yep. Oh, yeah.
Okay. So David Wright, SWGF on UK Safe Internet Centre, and it's a question about Part 5 and really enforcement. So since 2015, we've operated a revenge porn helpline, so we support adults victims of non-consensual intimate image abuse. And when we report content, 90% of that content is removed. Exactly the same, that's slightly higher than the Australian regulator in terms of content takedown. Our issue is typically in very small services that are set up specifically to host this content, often in Russia, in South America, or in parts of the Far East. And I'm intrigued about enforcement and legal enforcement, about how you expect that's going to work with sites based in Russia, specifically.
Yeah, so for enforcement and specifics of our strategy, we can't talk specifics of the strategy right now, but I think it's important to note that there are those cases where all of our talk of kind of proportionality and fairness and targeting, they are less relevant because, like you say, they're clearly set up for the purpose of creating harms to people online. And we will be kind of taking very swift enforcement action. We have kind of good suite of tools to issue banning orders if that needs to happen to protect UK users. And those specific cases where we can't see that there is a kind of proportionate way of dealing with those services, other than shutting them down, that is what we're set up to do with our powers under the Online Safety Act.
Hi, Alistair Graham from the AVPA. Just a little bit more detail on that one. When you say blocking, is this does this require going to court, or do you have the powers to do that without the court case? I'm minded of what happened in Germany when X-Hamster. It took 2 years for the Germans to take X-Hamster to court because they weren't doing AV. They got to court, they lost, and within about half an hour they just changed the domain name around, and they're still operating, waiting for another 2 years for the same conversation. How are you avoiding that happening in the UK?
So yeah, like I said, I think the X-Hamster example, we probably take a slightly different approach to the German regulator, and that's why we have set up in that way to build those supervision conversations, to have those big services with those big resources that a lot of UK users access. We are having conversations with, we are talking about how they're going to comply, and we are making sure that day one there are no shocks to us and there's no shocks to them, and they know what the expectations are, so that we're not being very sort of combative with those services and ending up in these kind of long, dragged out legal battles when no one really benefits. Maybe the services that are trying to evade complying. we do have to take court orders out to issue blocking orders, and we will be prioritizing those most dangerous, most hard to work with sites for doing that kind of thing. And it may take time, but that is just the system that we have to operate with, and the powers that we have.
Yeah, I think I would also just say, like, I think the point is that supervision is starting now for a lot of these services. We're not waiting until things are sort of more formal and that the codes have been published and formalized. So all of that work is starting and it has already started. And I think we've also learned a lot from the VSP regime. So I think we're building on that experience as well to be ready on day one for enforcement if necessary, supervision if necessary, legal recourse if necessary. So we're trying to kind of build on that wealth of knowledge.
Thank you. Julie Dawson from Yoti. So just building on the previous point from Alistair, in terms of blocking orders, is that a one-by-one, individual company by company, or as was raised during the consultation and the discussions in the Lords, is there the possibility for multiple blocking orders, given that we know there's many tens, hundreds, thousands of sites, or will you have to go one by one? We'd understood there was a multiple option.
I think that's my understanding too. I think I wouldn't want to answer as a lawyer and have someone, when I go back to Ofcom, a lawyer chasing me around the office saying I've said the wrong thing, but I'm pretty sure that it would have to be assessed on a case-by-case basis, and there would have to be reasons for grouping, I think. But I understand that we can do multiple blocking orders.
Hi, Eden Tyatt from the Centre for Information Policy Leadership. How closely do you work with the ICO, specifically when it comes to these measures that you've suggested that be highly effective for age assurance?
So yeah, we work very closely with the ICO. You can see the ICO responded to our public consultation, and then their response is public on that. So that's quite a good, I think, quite a good test of how closely we've worked together. Because I think the feedback is mostly that they're kind of very happy that our approach sits well with their work and can be complementary. And we just want to work closer and closer. So I think wherever there is a lack of clarity for services or stakeholders on how the measures interlink, we're happy to kind of come to the table jointly or kind of work together to publish things to make super clear how the two things tie together, so that this kind of has a limited burden on services and that no one regime should be complied with at the expense of another. And we think that's completely possible. And I think the ICO issued their opinion on age assurance earlier this year, which is also a really good testament to how these two things can be done together. And then also we work together through the Digital Regulation Cooperation Forum and bring in a kind of our other regulatory friends through that forum. And yeah, it's a really close working relationship. I meet with some of you guys at the ICO more than I meet with my own colleagues. So yeah.
Jason O'Mahony, Children of the Digital Age. I'm just curious as to how much of a buy-in are the pornography providers going to give in relation to what we're talking about here, because I'm sure you've seen yourself in the States that I think was it Texas or someplace there got a law passed, and ILO or MindGeek, whichever you want to call it, came out and blamed their local government for basically saying you have no longer access to porn because of your own people. Like, so if they're doing that in parts of the world, how can we be sure that they're going to play ball with us over here as well?
Yeah, it's part of it's my job. So yeah, no, we're fairly confident that won't be repeated. I think pornography services know the tide is changing, and we are one of many jurisdictions where this is happening, and they can't keep obfuscating. And I think, like Arietta said, we are meeting with them now. They understand what's expected, and I think we have good expectations that when day one of these regulations kick in, we will see compliance. And yeah, I think because of there's that feeling of, okay, this is inevitable now, this is coming around the world, we're fairly confident.
Hi, hello. I'm Martin Sass from the KU Leuven. I'm a doctoral researcher and I'm working on privacy. I like the fact that you're going to be in collaboration with ICO. But I'm wondering why not taking the privacy perspective as an ex ante criteria into your guidelines as well. That, for example, the different methods you were showcasing as being highly effective. You mentioned the pairing of identity card or identity document with a photo. From my perspective, if you have to provide that to access a porn website, that's quite problematic and very privacy intrusive. Is it a good idea to highlight those type of methods directly into your guidance, or should also take the privacy criteria into consideration in an ex ante process?
Yeah, no, it's a really good question, and we kind of worked with the ICO and we think it's better, and there's better regulatory certainty if we don't cross into each other's lanes. And so wherever possible in our guidance, and if it's possible to do it more, we really welcome people to point that out to us so we can, in our final version, make it even clearer. We want to be pointing to the ICO's guidance on these things that might say, for example, that it's more privacy preserving for a pornography service to use a third-party provider, so that pornography service never sees that person's photo ID. They just receive information that they are over or under 18, and other things like that. So yes, we don't talk about it in our guidance, and we recognise that that could cause it to not be as clear for services. So we really want to work very hard as we move towards our final guidance to wherever there is an opportunity to refer to the correct guidance by the ICO and make sure that people are taking those into consideration. We can make that as clear as possible without sort of creating that confusion of crossing into each other's lanes and talking on things that we're not as qualified to talk about. Quite frankly, the ICO are the real experts on that.
Also, so in our guidance itself, in the Part 5 guidance, we do make reference to, this needing to be done in a privacy preserving way. And then instead of going into all the details, we point to our ICO colleagues and all of the existing legislation around data protection and so on and so forth. As Annie says, it's not our duty to sort of encroach further in that territory, but we do say that services need to kind of consider that. And also they should be complying with it anyway, because that's existing legislation right now. In terms of ID cards specifically, I think any form of age assurance, as Annie said, it's about the way that it's implemented. And so long as it's implemented in a way that meets all of the other criteria, including existing data protection, I don't think that that's a particularly bad method in and of itself. It depends on how it's done, whether it's privacy preserving, whether it's technically accurate, whether it's robust, whether it's fair, et cetera, et cetera. So that's why we sort of mentioned it, because it obviously could be technically accurate, but again, depends on implementation.
Actually, I just realised the question is really probably for the ICO, so you can just tell me it's an unfair question. The ICO, when the Digital Economy Act was around, the ICO did not step in to say that it was a bad idea that porn companies should be collecting people's identity information alongside all their sexual habits. But have they made a change in that position? Are they publicly saying that the adult companies shouldn't be doing this, or are they still keeping the same position as they did last time?
Okay, hello. As far as I'm aware, we haven't made that statement. I'd say porn companies are data controllers like any other organisations. Some might have really good privacy preserving measures in place, others might not. Everything's a case by case basis. I'd say, yeah, if there was a privacy incident or something like that, then it would come to us and go through our enforcement team. But I don't think that we were going to be making statements on whole sectors, as far as I know. They should all be complying with their data protection obligations. Yes. Do you agree? Mm-hmm.
The numbers we're talking about, the 25 million UK citizens, there's a lot of potential for data don't want to do it that way rather than wait for something to go wrong. To have all that data in sites that have been non-compliant for years, that do not have a record of looking after personal data. When we're talking about millions of pieces of personal data, this is a sort of national security issue, data security issue. Why does the ICO not step up more?
I think I don't have anything else really to say than that. I think, I don't know if there's like research and evidence that would suggest that there has been a data breach and that they're not complying, then it would come to us. But yeah, we've got our opinion on age assurance. It should be conducted in a privacy preserving way. If it isn't, then, you know, and it meets our enforcement criteria, then that's the kind of action that we would take. But I'm not sure that we would say sort of one whole sector isn't compliant and that they have to do something in a very specific way. It should be on a case-by-case basis, and, you know, data protection's been around for a while, so they should be complying with data protection in terms of their other data processing practices, and age assurance is exactly the same. You know, they need to meet all the principles and standards, and we've got that's in UK GDPR. They need to comply with the Children's Act as well. And then also on top of the Children's Act, we've given them the age assurance opinion, which gives even more advice on how to comply. So there's a lot of resources out there to help these organisations. There's also our likely to be accessed guidance, so that adult sites can see, you know, if children are or aren't accessing, and it tells them how to sort of maybe assess that and how to apply measures in a risk-based and preserving way. So I think we've got quite a lot of resources that are available, but I think it would be quite a big statement to say this one whole sector has to do something in this very prescriptive way. I think probably it'd be a more holistic approach than that. Don't know if you have anything to add. Well, that's true, but yeah, I didn't expect to answer a question, so I haven't been prepped for that at all. So if I've said anything kind of out of sorts, but that's my understanding. So
Just to mention that there are session, ICO sessions tomorrow. Be careful at this conference through the sessions that we are playing with those panels.
I'm just curious. We'd say you're saying you're supervising from now. We'd say moving forward. Obviously, deepfake image abuse now is gone crazy, and there are apps that you can download that can, you know, generate from a clothed person to a naked person. We'd say today, from day one, if somebody is impacted negatively by that, how long is it going to take from today to either get an app removed or get a site removed, moving forward?
So that would be that those duties fall under our illegal harms duties, so they won't come into force until we publish the codes and guidance later this year, and then there's a period of 40 days where they have to sit in Parliament, and then they are enforceable. Then we will have our powers to then pursue those. And if you look at our online safety enforcement guidance, you'll see how we'll be prioritising action on that. But I will say that this is an issue we're very alive to. We can't take enforcement action until we have the legal force to do so, but we have the ability to do research to understand exactly what's going on, and that is happening in Ofcom right now to kind of understand this emerging risk.
Obviously, like there's multiples of apps and sites and stuff like that these available, and actual deep foreign or deep fake porn sites themselves. If you take an action, is it then just for one site and just in the UK?
So for the UK question, we have a duty to protect UK users. So if it can be accessed by UK users, then we can take action against it. It doesn't matter where it's headquartered. And we have a range of enforcement tools, and they kind of all work in different ways. But like I said, the blocking orders that we spoke about, we could be taking action against multiple sites. There's penalties that we could apply to those sites if they're operating in the UK. So they're kind of, it depends what enforcement action we're taking, but yeah, we're not going to be we're hoping the plan is not to be kind of a slow, inefficient regulator doing a kind of whack-a-mole against these sites.
would a VPN bypass any blocking measures that you put on here in the UK?
Yeah, so a VPN could be a way of blocking, of bypassing, and that is a kind of a clear fault with what we're working on.
But right, so we're aware of the VPN issue. It's a challenge, but we're working within the constraints of what the Act says we can and cannot do. It doesn't say that we can ban VPNs. I don't think for a lot of reasons that wouldn't be a positive thing. But also within our criteria on highly effective age assurance, one of the core criteria is robustness. So we say that services should not be promoting, let's say, VPNs as advertisements alongside their service, because that's a very clear, could be potentially a clear way that they would circumvent the protections that a user would have under the OSA. So we're aware of the VPN issue, where service is using this to kind of, nip at the robustness criteria, and they're not fulfilling the robustness criteria, for instance, via promoting VPNs alongside their service, we can still take enforcement action where appropriate. So we're aware of it, we're working within the constraints of the Act, but also doing what we can to kind of circumvent where possible.
And also important to say that this is not so much an issue for our Part 5 guidance, because where images are being made without people's consent, we're not considering that pornography. That is under our legal harms. We'll have the powers on those first, and that is very, very important and serious for us.
Sorry, I'll just this VPN issue. Obviously it's a contentious topic, but I think when it comes to protecting children more broadly, I think the harm today is that a lot of children can stumble across pretty vitriolic, awful pieces of content and other types of harms, sometimes without looking for it, sometimes with easily looking for it. So yes, the VPN issue is a challenge that we have to be aware of, but for the vast majority of children, we know that the way they encounter harm is just by, their sort of normal experiences. So I think it's important that, the perfect not be the enemy of the good in this, and that these edge cases are really important to consider, but we also are going to be making substantially, beneficial policies that will change the way that children experience the internet in a much sort of safer way. So I think it's important to also acknowledge that as well.
Hi, I'm Frank Hersey, a reporter at MLEX. I was just wondering how you're going to be checking on whether or not sites are advertising VPNs. And then a slightly different question that I've been holding back a little bit, just on the supervision team. Just any comments on what that experience has been like, having a supervision team in place, working with companies, and how that's different to typical circumstances? And is it like a pilot that might be brought to other regulators?
Yeah, so on the supervision point, I'm not sure if, we work very closely with other regulators. So we're always sharing knowledge and that sort of thing. I can't speak on their behalf in terms of what they're going to replicate from our sort of model. But it's just, it is sort of foundational, like stakeholder building. So they will have their relationships, whether they have a specific supervision team, that's not for us to speak on. But we've also, so this is not, we have this team set up under the VSP regime as well. So it's a new team to Ofcom, but it's also existed under the video sharing platform regime. So we've been able to maintain and start those relationships from there, and then carry them through where those services are also regulated under the OSA. And I think it's a pretty effective team, because there isn't that sort of, the enforcement team, as you can imagine in legal, have a slightly more, let's say, contentious relationship as is appropriate, where supervision, I think, is a great opportunity to really learn the ins and outs of how services are working, what challenges, as Annie said, they are identifying in compliance, in future compliance. A lot of these services realize that the tide is turning, they have to comply. The days of being able to kind of avoid all regulation is not, has truly passed. And so I think those constructive relationships are going to be a key way that we get this buy-in for the policies to actually work and be implemented effectively.
Also on that point on supervision, the model is used by the FCA. So we've had people come from the FCA, a few colleagues who have kind of taken that model they've worked in and kind of taken the bits of that we think are useful for online safety regulation. So that's sort of where some of that, and I'm sure there are other regulators that do operate it, but I can't say that my regulatory knowledge is good enough to say. Yeah, so yeah, that's kind of if you want to look elsewhere for that kind of thing. Okay, we've got time for one more, have we?
Yeah, we have reached the time limit. So yeah, we'll extend for a few more questions.
Thank you. So just building on that point with regards cooperation with other bodies, I wondered if there is close collaboration already with ad networks and payment processors on the old adage of follow the money.
Yeah, in short, yes, we're meeting with payment providers. They have a lot of knowledge in this space, and we want to take that. So yeah, the short answer is yes, there is.
So, quick question about the intersection between Part 3 and Part 5. Given that, I'm just wondering about loopholes. If you take Google, for example, they fall in the user side, but that's the way that most kids get to porn, is by Googling porn. I'm wondering, might you guys consider saying to Google, other search engines do exist, that you should enforce safe search, and I mean enforce, not turn on, by default. So we work with schools, and we at a network level enforce it, and then it generally works quite well. Then they go home, and you have to either use Google Family Link or be a technical genius to enforce it at home. Could you see yourselves saying, look, for the benefit of Part 3, for the benefit of Part 5, Google or home broadband provider, you must enforce this via DNS or whatever, and then prove you're an adult to get safe search turned off, because that will help in both parts. It will solve all sorts of mysteries. If not, could you please?
Over to the Part 3 guru.
Yeah, I mean, you're not going to like my answer, because it's going to be that I really can't speak about the specific measures when it comes to Part 3. It wouldn't be appropriate for me to do so, since we're publishing very soon. But we will have measures on search services and what they need to do in order to comply. We'll have measures on user-to-user services. And obviously, Annie and I are in the same team. We work very closely together. We're very aware of the potential gaps, so to speak. And we've prioritized alignment, but also proportionality in all of the measures that we're able to kind of come up with, and that the Act allows us to mandate as well. So it's a bit of a disappointing answer from me on this one, but respond to our consultation. Hopefully you like the measures. If you don't, still respond. Really helpful feedback. But potentially we'll be able to speak to this pretty soon about the specifics. So hopefully I'll be able to answer your question in a little bit. Ask me again in a couple of months. No comment on anything else.
We'll go for one more question.
Thank you. So my question relates back to the point about nudification apps. So nudification apps are something that we're finding now being reported by victims via the helpline, so routinely. And we're routinely then reporting nudification apps to app stores. My question is more about app stores. Now, and you say, Annie, about whack-a-mole, but if app stores, and you can correct me here, fall outside the scope of the Online Safety Act, surely we are going to be doing whack-a-mole. So we're reporting them, and to be fair, Apple are taking them down. Google are not, on the premise that they are, and I'm paraphrasing here, not illegal. Some of them are specifically created, and it's pretty obvious the purpose of these specific nudification apps. It leaves little to the imagination. So my question is, I suppose one for Apple is, and all app stores, is if it violates your terms, how are they getting there in the first place? Given apps don't accidentally appear, they go through kind of some routine. But I guess it's all because app stores are going to be outside of the scope. So how are we not going to do whack-a-mole?
I mean, you've hit on it there. We can only deal with the Act that we've got. So if something's outside of scope, we're not going to be able to enforce against it. We are kind of doing forward-looking research and trying to understand where there are gaps in the Act, and see how we can work with government to make children's life online safer, everyone's life online safer when it comes to nudification apps. And yes, and when it comes to kind of that kind of whack-a-mole point, it's about sort of looking at how we can deal with services in groups, how we can how we can use our compliance powers effectively so that we're not chasing after people. And I think that will become clearer as our powers come into force and we're able to speak more about how we're talking about compliance. We don't want to do that too soon and kind of show all our cards when it comes to compliance. But yeah, it's a massive challenge, and it's a kind of a real new challenge for us, real novel challenge for kind of regulators all over the world. But we are talking to government and we are working closely to understand kind of what we can't do with the Act, as well as kind of really focusing on what we are going to be able to do.
Just one final point on that as well. So our May consultation is coming out, and I think this is the kind of primary opportunity for stakeholders to be submitting evidence where they think things should be within scope. And also where, you know, potentially harms are hosted on regulated services. So if there is a gap in whatever measures we're putting out and you disagree with it or you have evidence to the contrary, the consultation is the primary opportunity to really give us that feedback, because all of our policies, for obvious reasons, have to be evidence-based. So I think that I would just point you to that May consultation and preceding consultations when it comes to categorization and app stores and all the rest of it.
The last one.
Does Ofcom maintain a domain blacklist for websites in the UK?
No, I don't think we're at that stage of our compliance yet. We are doing research, we are understanding what's out there, where the harms are, but we're not, like I said, if the timetable we showed at the start, kind of, it's not until we get our powers that we will have compliance. So we are building that knowledge base now, so that we know where our focus is going to be and how we're going to target that compliance. And like, we have a full suite of compliance measures. So that is the most extreme case, and we know there are going to be cases where they are going to need to be used, but there will be cases where a penalty first makes sense. There will be cases where we are kind of supervising people first and having kind of constructive engagement. So that is kind of one tranche of our engagement, is understanding where the the kind of really terrible things are that we are going to have to use the top end of our measures for. But I couldn't comment on a kind of a blacklist, so to speak, as part of our compliance policy development. It was
Thank you, everyone. Thanks for the participation.
Thank you so much for your help. Yeah. There's someone else in this room.
Can we leave things here? Should we bring the professor?
Yeah, I clear this.